Cops are completely immune from lying on the stand. You can never go after a cop for lying on the stand. Even when you know it's a blatant lie, there's no civil remedy.
But we watched it in Henry Green's case.
Sure.
We watched it.
Sure.
So I am in Cleveland, and I'm so excited, so honored to be sitting here with you. I'm Carla Carey from Ohio Families Unite Against Police Brutality, and you are?
My name is Sarah Gelsomino. I'm a civil rights lawyer here in Ohio with the law firm of Friedman, Gilbert, and Gerhardstein.
Excellent. So I know you on a personal level, and so I'm so excited to be here in this beautiful backdrop of your porch. So really,
you're here.
Yeah. So really what I wanted to talk to you about briefly is qualified immunity. Like, I know you have a lot of cases, and how does that affect your cases?
Oh, qualified immunity impacts our cases in so many ways. All of police accountability, really, in so many ways. But the problem with qualified immunity is it keeps us from being able to tell these stories to a jury, to be able to put forth the truth of what police violence does to people. And so that's the problem. Qualified immunity allows judges to kick civil rights cases and police misconduct cases out of the court without ever allowing us to present it to a jury.
Wow. How many cases are you currently working on?
Oh, Carla, a
That
lot.
many?
I have a lot. You know, there's unfortunately a lot of police violence in this state, and we do cases outside of the state as well.
Okay.
But
how far have you gone? Like, I know you're mainly Cleveland, but do you come to Columbus, Cincinnati?
oh yes, I have cases all over Ohio. We have cases in Kentucky. We are currently litigating a police shooting case in New York, and last summer I had a police shooting case in Virginia Beach, which actually
Really?
got to a jury.
Did it really?
Yeah.
So how many of your cases on an average do you see go to jury?
So in the criminal legal system, most civil cases don't go to a jury,
Okay.
period.
Okay.
Most cases settle. We thankfully, in terms of successfully litigating cases, right, in terms of not losing to qualified immunity, thankfully we have a pretty strong track record of being able to defeat qualified immunity. However, so many cases that I care so deeply about, and so many cases where I know that the police were acting wrongly have been lost, unfortunately, at the appellate court and at the trial level court to qualified immunity.
That's so crazy to me. You know, we were just in the court with the Henry Green case, and just to watch it play out for a second time and still have the same end result was disheartening, because you know that those police officers are lying. So I know when we were chatting earlier, you had mentioned something about police officers, and when they lie on stand, like there's nothing that can be done. Why is that?
Qualified immunity is just one type of immunity given to law enforcement.
Okay.
There's also absolute immunity sometimes, and there's absolute immunity for lying on the stand. And then there's prosecutorial immunity, which means that's absolute immunity. And so absolute immunity means that we can never go after prosecutors, even when they intentionally violate people's constitutional rights. As long as they're acting as a prosecutor, they're protected by the law. And then, of course, there's judicial absolute immunity as well. So there's these multiple layers of immunity within the criminal legal system that, in my opinion, just disincentivize people from following the law, unfortunately. You know, I mean, if people are totally protected, if there's no fear that they are going to be civilly liable,
Right.
and there's no realistic fear of them being criminally held responsible, then unfortunately what we see is time and time again, these government actors can act wrongfully, can violate people's rights, and they do it with impunity. You know, the other thing about qualified immunity that we don't often talk about too, and I think this is something that you probably witnessed in the Henry Green trial and retrial, is that qualified immunity is a defense that officers can raise time and time and time and time again. They can raise it at the very beginning of a case to try to prevent the case from ever moving forward.
Right.
They can present it at summary judgment in the middle of the case to again prevent the case from going beyond that and ever getting to a jury. And then even at the jury, once again they can raise qualified immunity. So even when judges have already determined that it doesn't, that qualified immunity is not a factor or shouldn't kick out the case, then the jury is again presented with this. So think about what that does to the mindset of a juror.
Yeah.
To read, oh, well, maybe they have this out.
Exactly.
You know, and so that's real. That's a huge barrier that we unfortunately have to confront at every step of the way. Yeah.
How do you keep the families holding on to hope when it seems so like such a small piece of hope is there?
Oh, Carla, it's so hard. It really is hard. I mean, that's why I'm so grateful for you all and the work that you do, because I think really pursuing justice in the courts, in the criminal legal system it's a thankless task, you know? I mean, hopefully we can recover some kind of financial, you know, recovery for families so that maybe kids can be taken care of, or families can be taken care of going forward. Or, you know, some of my clients are permanently injured by police, and so maybe they have something to help them get the care that they need going forward. There's value to that.
Absolutely.
But we need a lot more than that to be able to really change this systemic, racist police state that continuously hurts people. And unfortunately, I don't think we're going to get that from the courts. That has to come from organizing. That has to come from the policy work that you all are doing. And so that's where I find hope.
Yeah.
I find hope in relationships with my clients, who become my friends and people who I respect and I look up to for guidance in all parts of my life. And, you know, people who we can work with and push our elected representatives to make the changes that need to be made to really make this system better, and prevent people from getting hurt.
And that seems to be the hard part for us right now, just trying to figure out what bills we need to attach ourselves to help get passed that will assist the families in the future.
Right.
So I have one last question to ask you. You had mentioned if a police officer is convicted, then the civil piece, what does that look like?
So, in order to recover under the Civil Rights Act in federal court, we're talking about federal court only, and there are ways to recover against police officers in state court as well.
Okay.
So and this is actually kind of true in both, but you have to prove that the officer was acting under the color of law and in good faith when he violated a clearly established constitutional right. Each of those are different barriers that have to be crossed. So, was the officer acting in good faith? When an officer is criminally charged and convicted, then the municipality can argue that he was not acting in good faith, because an officer is acting under good faith shouldn't violate the law.
Correct. Right.
So that's an out for them, so they can refuse to indemnify the officer. And what that means is there will be no money ever to the family, because the only money that would be available to recover would be money from the officer himself or herself, not from the insurance or from the municipality.
Right.
And, you know, in reality, there's not much there.
Exactly.
So it's just another way to, you know, prevent families from recovering anything financially from these civil cases. And you know, the only remedy available under the law, under civil law, is money.
Yeah.
That is the remedy that the founders of this country created for civil liability. So when the government puts up all of these barriers to the only type of recovery available to us, to families under the law, that hurts.
So many loopholes.
So many loopholes.
And unfortunately, I don't think families are aware when they come into this fight exactly like what direction to go, let alone all of the little bits and pieces of the laws that aren't in their favor. So for me, that's why it's so important that we've built this relationship with you. You continue to teach us, you know, the areas that we need to know what direction to go in. And aside from like this personal little friendship that I feel that I have with you, I'm so grateful to have met you and to be able to just bounce things off of you to find out where we need to go. So for that, I am ever so grateful, you know, for who you continue to be, for the families that we work with, and to me. I mean, you've never not taken a phone call whenever I've reached out to you to give us guidance on if something is legitimate or if something you could maybe speak to a family about that they're not sure about. So I really and truly appreciate you for those things, and for welcoming us this evening. I thank you so much for your time, and look forward to working with you in the future.
Always.
Thank you.
Thank you, Carla.
So how many of your cases on an average do you see go to jury?
Time.
Well, damn. Your turn. Tag, you're it.
How many cases do you see go to jury? Wait a minute.
In case he's on car patrol.